Hello, thank you for taking the time to view this training as we will explain to you some of the basic eligibility requirements to you as a non-ombudsman. Under USERRA, employers must provide service members employees with re-employment rights and benefits when the employee is absent from work because of his or her service in the uniformed services if the service member meets all eligibility criteria. Understanding the general provisions of USERRA is essential for both employers and employees, as it ensures that service members can fulfill their military duties without sacrificing their civilian careers. These provisions highlight the foundational elements that protect against employment discrimination, guarantee prompt reemployment, and uphold the benefits of employment for service members. By comprehensively understanding these provisions, participants will be equipped with the knowledge needed to support USERRA compliance. When the Uniformed Services Employment and Reemployment Rights Act, USERRA or the Act, became law on October 13, 1994, it was intended to encourage non-career uniformed service, minimize disruption to individuals performing service and their employers, fellow employees, and communities, ensure prompt reemployment of those who have served or serve in the uniformed services, and prohibit discrimination and/or retaliation based on an individual's service or affiliation with the uniformed services. 38 U.S.C. Chapter 4301 through 4335, the permanent law written and codified by the United States Congress. Written for all U.S. employees. 20 CFR Part 1002 is a plainly written portion of the regulation and has been written in an easy-to-read organized question and answer format. It was written for public and private employees. 5 CFR Part 353, similar to 20 CFR but specifically written for federal employees. Is the regulation also written in an easy-to-read question and answer format? One of the most common USERRA violations is improper termination based on military obligations. This is prohibited, and here we'll discuss why in accordance with USERRA. Under USERRA, discrimination while in the uniformed service may not be a motivating factor in an adverse employment action. This includes adverse actions based upon past, present, or future uniformed service. Denial of rights or benefits of employment, a broad term, includes opportunity to select work hours or location. Initial hiring, promotions, termination, job assignments, or other status issues. We've discussed how to identify and address potential discriminatory behaviors against military service members and the protections under USERRA. Here we will discuss hostile work environment in detail. A 2011 amendment to USERRA added terms, conditions, or privileges of employment to the definition of benefit of employment. These elements are a pattern of harassment severe enough to alter conditions of employment, a workplace was both objectively and subjectively offensive, and harassment took place on account of service members' protected status, activity. This also may include being reemployed in significantly lower position. When present, the service member may resign, but will have claim for denial of employment rights under USERRA. Understanding retaliation under USERRA. The definition of retaliation. Retaliation occurs when an employer takes adverse action against an employee for engaging in protected activities under USERRA. Protected activities. Activities protected under USERRA include exercising or taking steps to enforce rights, assisting in or testifying in USERRA investigations, and seeking ESGR mediation assistance. Protected activity may not be a motivating factor in adverse employment action. Service member exercising or taking steps to enforce rights under USERRA. Any employee assisting or testifying in USERRA investigation, whether they have performed service in the uniformed services, may be tied to other USERRA violations, such as failure to properly reemploy. Includes ESGR mediation assistance. USERRA provides protections for service members, ensuring their civilian employment rights are preserved when they are called to serve in the uniformed services. To be eligible for reemployment under USERRA, service members must meet 6 key requirements. Each of these gates serves as a checkpoint to ensure the service member's eligibility for reemployment. These 6 gates of reemployment are 1. Hold a position of employment. 2. Prior written or verbal notice. 3. Leave for the purpose of service. 4. 5-year cumulative limit. 5. Eligible discharge. 6. Timely application for reemployment. Employers must understand and comply with these 6 gates to uphold USERRA rights and avoid legal consequences. Ensuring that service members are aware of these requirements helps protect their employment rights and supports their transition back to civilian work. Gate 1. Hold a position of employment. USERRA rights are not diminished because an employee holds a temporary, part-time, or seasonal employment position. USERRA rights are not diminished because an employee is serving a probationary period. When reemployed, the returning service member might still need to satisfy a probationary requirement, depending on employer practice, state law, or other conditions. It's case by case. Remember, service in the uniformed services is deemed service with the employer with regard to seniority-based benefits, pensions, etc. If an employee is laid off with recall rights, on strike, or on a leave of absence, he or she is an employee for purposes of USERRA. If the employee is on layoff and begins service in the uniformed services, or is laid off while performing service, he or she may be entitled to reemployment on return if the employer would have recalled the employee to employment during the period of service. Similar principles apply if the employee is on strike or on a leave of absence. If still would be on layoff, the employee remains on layoff. Reemployment rights under USERRA cannot put the employee in a better position than if he or she had remained in the civilian employment position. Remember, withdrawing a job offer because the start date is delayed due to military service is a violation of Section 4311. Gate 2. Prior written or verbal notice. USERRA does not specify how far in advance notice must be given to the employer. Department of Defense Instruction 1205.12, strongly recommends that advance notice to civilian employers be provided at least 30 days prior to departure for uniformed service when it is feasible to do so. Prior or written or verbal notice is sufficient when notifying the employer. Must be prior to the next scheduled shift. Notice merely has to indicate leaving for service. May be excused. Resignation cannot waive reemployment rights. Notice does not imply that service members needs employer's permission. Gate 3. Leave for the purpose of service. Most types of uniformed service are protected. Those that are not covered are the Civil Air Patrol, Merchant Marine, Coast Guard Auxiliary, state militias, and state guard duty. Under 38 U.S.C. 4301. The term uniformed services means the armed forces, the Army National Guard, and the Air National Guard when engaged in active duty for training, inactive duty training, or full-time National Guard duty, the Commissioned Corps of the Public Health Service, system members of the National Urban Search and Rescue Response System during a period of appointment into federal service under Section 327 of the Stafford Disaster Relief and Emergency Assistance Act, and any other category of persons designated by the President in time of war or national emergency. National Guard duty under state authority, state active duty. Recent amendment, effective January 5, 2021, extends USERRA to National Guard members serving on state active duty in the following situations. A. For 14 days or more. B. In support of a national emergency declared by the President under the National Emergencies Act. Or C. In support of a major disaster declared by the President under Section 401 of the Stafford Act. ESGR can educate and inform service members regarding state active duty issues but cannot mediate cases. State active duty cases should be referred to Department of Labor Vets and/or to your Ombudsman Director. Gate 3. Leave for the purpose of service. The service member does not lose USERRA protection when absence is also used for other purposes, including moonlighting. If orders are changed or canceled after service member leaves employer, there is no loss of USERRA protections. Service member is entitled to sufficient time to prepare to arrive at duty station, fit to perform service. This depends upon 1. The duration of service, 2. When notice received, 3. The location of service. This also may require intermittent time off to arrange affairs prior to military leave. Gate 4. 5-year cumulative limit. An employee may perform service in the uniformed services for a total of 5 cumulative years or less and retain the right to reemployment with each employer for whom the employee works. Certain types of service are excluded from the cumulative 5-year limit, such as involuntary extensions and service during times of war or national emergency. This is the period of service, not the absence. It is cumulative with the employer. New employer, there is a new 5-year limit. There are numerous exemptions. Who in DoD can determine which service counts? This is the service component. Gate 5, eligible discharge. The individual must be discharged from service under conditions that are not disqualifying. Eligible discharges: honorable discharge, general discharge under honorable conditions, and certain other discharges. Disqualifying discharges are a dishonorable discharge, a bad conduct discharge, or other discharges under less than honorable conditions can disqualify an individual from reemployment rights. Gotch 6. Timely application for reemployment. In order to be entitled to reinstatement, an employee must timely submit an application for reinstatement. This application must be submitted to the employee's pre-service employer or an agent or representative of the employer who has a clear job responsibility for receiving employment applications, like a supervisor, HR representative, etc. The individual must submit a timely application for reemployment after completing their service. The time limits for applying for reemployment depend on the length of service. Service of 1 to 30 days. Application must be made no later than the beginning of the first full, regularly scheduled work period on the first full calendar day following completion of service and the expiration of 8 hours after a period, allowing for safe transportation from the place of service to the individual's residence. Service of 31 to 180 days. Application must be submitted no later than 14 days after completion of service. Service of 181 or more days. Application must be submitted no later than 90 days after completion of service. Exceptions. Extensions are allowed for hospitalization or convalescence from injuries incurred or aggravated during service. Thank you for your attention during this non-ombudsman training to familiarize yourself with ombudsman-type issues associated with USERRA. You should contact your Ombudsman Director if you have any questions or need help in facilitating the questions of a service member. Immediate assistance may also be received by contacting National Headquarters also.